So welcome to this week's episode of Thrive, your agency resource. Today I'm here with advertising, marketing, and promotions law attorney, Audrey Glover-Dichter. Welcome to the show, Audrey. It is so good to see you again, and I'm so happy you could make it.
Thank you so much, Kelly, for having me on your show today. I really appreciate being here with you and with everybody. Thank you.
So today we're talking about influencer contracts and legal review. And we sort of have to start by talking about the fact that marketing during a pandemic does not need to stop. I know I'm getting a lot of questions about that. Maybe you are as well. But you say that this is actually the perfect time to be able to pause and review everything that needed or currently needs to be reviewed, whether that applies to our existing content, our planned campaigns, things that we may not have had the quote unquote time to review before. The whole point of marketing is to build trust, right? So now we have this point, this moment in time where we have that ability to pause and take the time that's needed. So how are you sort of advising your clients from that perspective?
Well, I have about 8 points, more or less. We can combine them real quick. But there's time. And I realize that in this crazy world that we're living in today, there may be a slowdown of business, which to me seems to be a perfect opportunity to do certain things. Like, for example, everything's always due yesterday or last week.
Oh, you must have experience with marketing agencies.
We're always rushing. So this seems to be the perfect opportunity to take a deep breath and take the time to go back and review your campaigns. Because at this point, there's certain things in campaigns that you're planning or you're scheduling that it's not going to be possible to go public. Like, you can't do billboards right now. I don't know about print. I'm assuming print is out of the question for the time being, temporarily.
Right.
But of course, social media you can. But this is the perfect time to take those campaigns and review them for legal compliance in English and Spanish.
Mm-hmm.
I like to review campaigns in the language that they're going to run in, just because you don't want to lose your message and consistency, but also obviously the main point being compliance, legally compliant. So I like the legal compliance review. Take the time to do it now. Under FTC law, technically you're supposed to review your marketing campaigns to be legally compliant before you go public, you launch publicly. I get that not everybody does that because not everybody has the time to take the time to go to legal, but it's absolutely necessary. Right. So take the time. It might be an extra hour, but do it, because it could really save you, the agency, the client, everybody, such a big headache and hefty fines if it's taken the wrong way.
Yeah, and that was actually going to be my next question, was like, what kind of consequences are there? Because it may be just that some agencies may not know, like, what are those consequences? What are those fines? What are the things that could happen if they don't go through these proper channels of review?
Well, this is the biggest thing where I tell my clients, if the client, the marketer, the business is being reviewed, just know, investigated by like the FTC, the FDA, the SEC, it doesn't matter who, or even the state attorney general's office, or even the self-regulatory bodies like NAD or CARU. If anybody's investigating the business for their advertising campaigns, if there's some legal issues, trust me that the agencies are being investigated alongside as well, because they want to know what the role of the agency is in that marketing campaign. So if it's a misleading issue, what role did the agency play in creating a misleading advertising campaign?
Right.
And the standard is always knew or should have known. So obviously there's a lot that goes into the knew or should have known, because it goes back to, well, what do you have from the client? What questions should you have asked? You can't just stick your head in the sand and say, oh, I didn't know. Ignorance is never, ever, ever a defense for any field of law. So if you see any red flags, ask the questions. Don't ignore it.
Right, right. And one of the other things that you and I have talked about in the past is that, from your perspective, agencies really need to be reviewing their advertising law contracts. You suggest twice per year, but at minimum annually. And I think a lot of the reason for that is because the laws change so frequently. So can you talk to that a little bit and like why you really recommend the twice per year?
Sure. As an advertising law attorney, I like to review the advertising law contracts from an advertising law perspective. Okay. And what that means is things, law is a living thing, believe it or not, and it changes constantly. So it is crucial, it is very, very important that you have your contracts reviewed and that you have the proper clauses written legally correctly with the correct legalese,
Right.
you know, to make sure everybody's protected. And if you need to get out, you can get out. But the most important thing is the last thing you want is to have an old clause in a contract that could potentially null and void the entire thing.
Hmm.
I mean, then what do you do? I mean, the incredible amount of issues that could potentially come up if that happens. It's like, so what happens to the scope of work and how are you going to get paid? Are you going to get paid? Do you need to sue to get paid? I mean, there's just so much that goes into it. So I prefer to do it on a twice a year basis just to make sure, because again, the law changes. However, of course, not everybody can or wants to do it that way, but at least once a year. And of course, when you're dealing with different things like influencers, there are very specific clauses that go into advertising law contracts, and depending on what they are.
Right.
For, I apologize.
That's okay.
And for influencers, for example, there's a whole lot of things, a whole lot of different clauses that you want to put in there, not just to protect the agency and the brand, but also how to deal with this person. This is a person,
Right.
right?
Right. And you are essentially like responsible for what an influencer says or does
Oh,
or
most
posts on behalf of your
definitely.
brand, right? So,
And there's a lot of litigation and enforcement going on right now because influencers may not get enough guidance on how to make that disclosure, that material disclosure that they need to make, or where to make it, or how to make it, or the perfect wording. So these are things that I help put in the contract so that everybody's on the same page, everybody understands what needs to be done in plain English.
yeah. And I would imagine, I know that we're kind of only a few weeks into this pandemic, but I would imagine that because everyone is really, or the majority of people are working from home, um, there is so much more online activity now, especially on social media than ever before, right? At one given time or over a pretty prolonged period of time. So I would imagine that those things are even more rife at this point because you've got so many people that are following more, engaging more, commenting more, right? So I would imagine that this is kind of, like you said before, a really perfect time to really look at those contracts and make sure, even if those influencers are active, they're actively promoting a brand or what have you, making sure that the contracts that you have in place as the agency with that influencer are obviously more important now than ever before. And that's sort of a consequence of the reality that we're in right now.
And what I like to do is, like I said before, I'm fluent in Spanish. So not only do I like to review the campaigns in Spanish that are going to be running in Spanish, but if you're going to have a Spanish influencer, like a Latin influencer,
Mhm.
perhaps it's a good idea to put like what hashtag in Spanish you want to have them use, given the very specific language, if it's going to be in Spanish, if it's going to be in English, because you don't want any wiggle room. You want to make
Right.
sure it's tight and that everybody again is using the correct language and the
Right.
correct hashtags to make that necessary disclosure. So that's what I like to do, because if you're going to do it in Spanish, it's just as important to get it right in Spanish as it is in English. And
Yeah.
yeah, you can just get in trouble for getting it wrong in Spanish as in English.
Right.
It doesn't matter. The law applies regardless of what language you're wanting it in.
Right. Right. I think that's a great point. So let's talk a little bit about online privacy policies and how information is collected. So I know we've got GDPR in Europe, we've got CCPA in California, and what a lot of people probably don't know at this point from the agency perspective, just because we are in the realm of COVID-19 right now, is that the SHIELD Act of New York, you just mentioned before we spoke earlier, the SHIELD Act of New York, the second phase of that has actually gone into place as of March 21st. So this is really brand new content, new policies that are in place. So if you could share a little bit about that, I think that would be really helpful, especially to the agencies who operate in New York or have any kind of business dealings in the state.
Sure. Well, the biggest thing pattern that I'm seeing is that it's the who is on the other side of your marketing online,
Mm-hmm.
especially your websites, obviously, because this really applies more to the online
Data
and
collection.
right data collection and privacy. Like how much private data do you collect? Is it identifiable? So the biggest thing is to me is always the pattern of who. So if you don't know who's on the other side looking at your website, right? So it could be a person from the EU sitting in New York. So guess what? Now the GDPR applies to you, right? Because it doesn't matter where the European person is. The fact that that person is European, the GDPR just attached, right? So the same thing with CCPA. It attaches if it's a California person sitting in New York looking at your website, because that person is a resident or citizen, well, a resident of California, then the CCPA attaches. So
What is CCPA, just for the benefit
it's
of other
the
people who don't know?
California Consumer Protection Act.
Okay.
And it's a GDPR wannabe. I mean, don't get me wrong, there's a lot of differences, okay? And it's,
I like that.
well, the guy, they had the
It's a good way to
GDPR.
remember it.
Yeah, right? And the SHIELD Act is another one, and they're all very different. But the interesting pattern is that, again, now the SHIELD Act applies to New York residents. So are you collecting data, private data, social security numbers, credit card numbers, bank card numbers, email addresses, like very identifiable data,
Mm-hmm.
right? That it could be breached and cause havoc, as we all very well know. So, but again, so that New Yorker could be in Paris, hopefully not now,
Right.
but so then the SHIELD Act applies because it's a New York resident sitting wherever that person may be sitting on earth.
Mm-hmm.
Because that person is a New York resident, the SHIELD Act applies.
Wow.
So I always tell everybody, remember that it's the who, not the where or not the what.
Mm-hmm.
All that comes after the who. So because we're so different, I always, advise my clients, look, just play it safe and make sure you're compliant with all three. And sometimes you kind of feel like, how do I do that? So what I like to do is I have GDPR language and you can click on GDPR page, and then maybe CCPA language and you click on the CCPA page. And now we're going to have to add the SHIELD Act because that just came into effect. And of course, because everybody's so busy trying to figure out how to work from home for people who haven't been doing it. And this whole pandemic thing is freaking a lot of people out, obviously for good reason.
Right.
It's not easy. So the SHIELD Act kind of fell through the wayside, and
Right.
people are not exactly aware that it does exist and it does apply because it is in full effect.
Right. I actually have a quick question about that, though, because you just mentioned specifically with websites, if you have a page for each of these acts on your website to show that you're in compliance or show how you're protecting data that is being collected, do you have to have an individual page for each of the acts, or could you just call it privacy, compliance, and data collection or something like that, and then have what you're doing for each one of these three on the same page, or does it necessitate an individual page per each act?
It depends. It depends on the client, and each act has a very specific based as to when it applies, when it attaches. Of course, it always attaches if, like I just explained, it's the who. Like the CCPA and the Shield Act also have, for example, in CCPA, I'm sorry, if I remember correctly, it's like $5 million in revenue, and then in New York it's $3 million. I know. So
I see.
use those numbers, whether or not it attaches. But because you can't, you never know who's on the other side, I always advise the client, why not just play it safe, regardless of what your revenue is. Okay. And the other important fact that I'm starting to notice is under the GDPR, and law changes all the time. In the general GDPR, technically, you're not exactly responsible for third party software. Like if you use PayPal, you're not responsible for PayPal, right? Because they're a whole different world and you can't control what they do.
Right.
But on the CCPA, if PayPal has a breach, now you also are connected to PayPal because you're using PayPal. So there's some responsibility there. Now, unfortunately, we don't have final regulations on CCPA, and so a lot is constantly changing. We don't have the final regulations for that. I'm not aware that there are final regulations of the Shield Act since it just came into effect. Right. So as those regulations become final, we'll have better understanding at how to word things. So that's what I'm saying. It's just kind of muddy right now.
Right.
Very gray.
Right.
Just these exist and it may apply, and the differences on how it applies, it may necessitate to have different pages. Different language, with different differences, because like I said, one requires no responsibility for third acts, whereas CCPA apparently is going to give you a responsibility for the third party. And I'm not sure where the Shield Act is going with this, so I can't say right now because it just came into effect. But yes, so sometimes it's just easier to have a different page for each one, or maybe one long page and say GPR, GDPR or CCPA. And I mean, it depends. I mean, it's not so much about the structure, it's about having the proper language.
Okay. So it sounds like you could theoretically have all of the compliance in one single page and just have it all put underneath a privacy policy. But there could be extenuating circumstances where it necessitates multiple pages. So again, just like checking in with your advertising law attorney. All right, so as we start to wrap up here, obviously we're in the age of entirely remote workforces, especially for agencies. We have no control over that, and we don't know what the future of that looks like in terms of time frame. So this, I think, is another opportunity to make sure that we are making sure that our employees are really trained on advertising law, you say, not in the context of having them, act as lawyers, but at least sort of being like a first line of defense in ensuring like checks and balances to protect your agency. So if you could talk a little bit more about that as we wrap up, I think that would be a great place to land, because this is not only from a professional development standpoint, but just from an agency protection standpoint, really taking this opportunity, to get on the same page and be really consistent with how we're understanding where we're getting our content and our images, and making sure that the copyright information is in place and all of that. So I'd love to just kind of hear your thoughts on that.
Sure. I'm a true proponent of in-house training. The main reason for that is, and again, like you just said, we don't expect you to be lawyers, but the whole point of the training is everybody should be on the same page with the same basic understanding on how the law attaches and applies to the work that you're doing. Yeah. Because, like I said before, if the marketer, your client, is being investigated, chances are that the agency is being investigated as well. So this is a great way to be able to have a basic understanding of how the law works, and depending on what you do and depending on the product or the service that you're working on, what you should be aware of. Where are the red flags? And then come up, and then after that, what I like to do is sit down with the agency and try to come up with some kind of a checkoff list to have some kind of a advertising law internal procedure policy. So it's just simple, a check off. Did we check for IP clearances? Do we need to do an IP clearances? And this is just an example. Like you're going to use this photo, and let's just use a photo, right? Where'd you get the photo? Did you just download it from somewhere on the internet? And is it clear to be used? Did you pay for it? Are you allowed to use it? Is it copyrighted? There's so much that goes into that. Did you get the photo from the client? Really? And what did the client get it? And are we allowed to use it? Is there a copyright attached to that? So what protection does the agency have if the client demands to use that photo, and whether or not that photo is copyrighted, and whether or not the client did do its due diligence as far as doing the IP clearance, as far as checking whether or not they can use it, that they pay for it and all that. I mean, if they're adamant about using it, then, and you're not comfortable about using it, what's the agency going to do about that? So what do you have in place to make sure that the agency is protected from using a photo that you may or may not be legally able to use?
Right, because if that client has a photo that they've obtained in a way where, let's say that the copyright information is in question, they're mandating that you as the agency need to use this photo in a campaign, yet you technically are going to be liable, right? If something comes out where the client is, investigated or whatnot, there's no way that you should go and use that photo without making sure that it's gone through the proper checks. So I think this is a really big thing, because I do see so many agencies, to be honest, like we probably did that at my agency. We probably didn't run all of the clearances and all the copyright information and 100% of the protections that we should have. I think this is a really good point. And now that we have the time to kind of like pause, I'm really talking about the pause a lot here. We have the opportunity to create a checklist and to train our people in a way that supports them, a way that supports our agency, a way that supports our clients. And in the end, that's really back to our value proposition. We're going to go through, as an agency, we're going to go through and make sure that you're completely compliant with every kind of piece of content, imagery, video, etc., if we're going to be using it in a campaign. So that's kind of what I hear you saying.
Correct. And really, I'm going to go back to my original point.
Yeah.
Under the FTC law, all campaigns need to be legally compliant before launching publicly. Mm-hmm. So the bottom line is, if you don't do that, then you're opening yourself to not just federal government issues and investigations and all that, but also potential lawsuits. And trust me, agencies do get sued. As a matter of fact, I have a whole presentation on the reasons why agencies get sued. And if you do your due diligence right off the bat, it may slow you down in launching publicly, but at least you minimize your legal risk. Because if you get challenged or sued, you can go in and hopefully nip it by showing all the due diligence that you've done, and say, look, I have how to support my claims. I have the IP clearances. I have this, I have that. And then hopefully if it is a lawsuit, it gets thrown out quickly. And as you know, everybody knows, lawsuits are very costly and time consuming. Right. So if you can get rid of that lawsuit immediately, think about how much time and money you're saving. And the same thing to having to defend at a federal government agency or a state attorney's agency, or even at one of the self-governing bodies. Because again, if you have everything done up front, then hopefully you're just completely minimize that legal risk and, minimize the cost and the time and the aggravation.
Yeah.
So it's well worth the time.
Yeah, absolutely. Well, Audrey, thank you so much for joining me today. This conversation has honestly been so packed with just a wealth of information and your knowledge. Really, really appreciate you coming on to the show.
Thank you so much for having me, and thank you everybody for listening. And I really appreciate your time and for inviting me. If anybody has any questions, may I give them my phone number?
Absolutely.
My phone number is 954-736-9787. And my website is www.advertisinglaw.legal. Advertisinglaw.legal. So
And
thank you so
I
much.
will, yeah, Audrey, thank you. And I will put that in the show notes. The website, obviously, if they, I don't want to put your phone number in the show notes, but yeah. So thank you so much again. This is really helpful, and please be well during all of this.
Thank you. You too. Have a great day, and everybody stay safe and healthy.
This episode has been brought to you by Workamajig, the #1 creative agency management software. Show notes at thrive.workamajig.com. Find out how your creative agency can become more productive and more profitable. Schedule your demo at thrive.workamajig.com.